Hi. In the fall of 1795, a saturnalia of corruption, as it was called, descended upon Augusta, Georgia, the capital of the state, as investors from the rest of the country swarmed in to bribe the legislature. What they wanted the legislature to do was to sell 35 million acres in what are today Mississippi and Alabama to these land companies. Now, the land agents who came to Georgia, armed with lots of cash, did not intend to move out to Alabama and Mississippi themselves. What they wanted to do was to bring this land, or the deeds to the land, back to New England and other places and sell them to other people. It's kind of land speculation. And according to some reports, every member of the legislature who voted for this, except for one, had been bribed. James Wilson, the Associate Justice of the Supreme Court, actually came to Georgia with $25,000 in bank bills so that he could bribe legislators and then buy land, as he had dreams of setting up a colony out in the West and bringing immigrants in. People saw this as an opportunity to get rich. So the selling price, Georgia got about less than 2 cents an acre. Within a few months, the land was selling for 20 cents an acre in New England. If you ever heard the phrase land office business, someone opens an office to sell land and then you buy it, not so you can move out there, but so you can sell it to someone else who might want to move out there. So Georgia does very well by selling this land, which Georgia had been trying to sell for a while, although the land actually was occupied by the Cherokee and the Creek Indians and the Choctaw Indians. So this is what's happening in Georgia. The legislature is bribed, sell the land. Governor of Georgia on the 7th of January 1795 signs this ordinance into law. And then what happens is quite interesting. William Crawford, a school teacher in Georgia, is outraged that the legislature has been bribed. And he starts a campaign to recall to vote out this legislature and to vote in a legislature that will act to revoke this ordinance. And one of Georgia's senators, James Jackson, is so outraged he resigns from the United States Senate, comes back to Georgia so he can run for the legislature and turn out the legislators who had voted for this horrendous law. And what outraged Crawford and Jackson was that just 2 decades after the United States declared independence, hoping to establish this new government, this new vision for the world, members of the legislature had been bribed. So this is what's happening in Georgia in 1795. Massive campaign now to turn out the legislature, and Jackson and Crawford are successful. The legislature is turned out, new legislature voted in. Georgia actually moved its capital to Louisville, Georgia, and the new legislature votes to rescind that old law. Not only do they rescind it, they have someone go to all of the state libraries where there are newspapers or law books which carry this law in it, and someone cuts out the offending law from every newspaper they can find. And then all of this paper is brought to Louisville, and in front of the state capitol, it's going to be set on fire. Burn it, so that the record will be expunged of the legislature in Georgia being bribed to sell this land as the legislators pursue their own vicious self-interest against the idea of the virtuous republic. And Jackson presides over this ceremonial burning of the law, and it's decided that this is actually too sacred a duty to be done simply by, striking a match or having someone, rub 2 sticks together. They get a magnifying glass and hold it over this pile of paper so that a beam of light from the sun can set the fire and expunge this deed from the record book. So Georgia is purified. Georgia has saved itself from these swindlers who were seeking to get rich at the expense of public virtue. So this is a good thing for Georgia. I think we can agree that the legislature had been bribed and the people of Georgia rose up in their righteous fury, turned them out, and then expunged the record. But meanwhile, folks who had bought the land, not necessarily the folks who had come to Georgia to bribe the legislature, but people in Boston, New York, Newport, who had acted in good faith, buying what they thought were, quite lucrative investments, now find themselves holding something that's worthless because the Georgia legislature had said, We didn't sell the land. These titles are not worth anything. So now you're stuck. You invested in this, and now it's worthless. Or is it? Some of the investors actually seek legal counsel. They go to Alexander Hamilton, now practicing law in New York, and ask him if the Georgia legislature really can rescind an act done under the law of Georgia. And Hamilton says no, because the Constitution, Article 1, Section 10, says that no state shall impair the obligation of a contract. Pretty clear. People had made a contract under this law, and now the state has impaired the obligation of the contract. On the other side, Abraham Bishop, a politician, a Republican politician in Connecticut, says, well, of course the Georgia legislature can do this. Yes, the Georgia legislature can rescind the law, and furthermore, the land didn't belong to Georgia in the first place. It really belonged to the Indians, the Creeks, the Choctaws, the Chickasaws, who were living there. So two different opinions on this. And it becomes a political issue. The Federalists say Georgia could not do this. It could not impair the obligation of the contract. And on the other side, the Republicans saying, well, of course, Georgia can. States are sovereign entities. That's one argument. The other is corruption shouldn't be paid off. We shouldn't reward corruption. Contentious issue. President Jefferson wants to settle it when he becomes president in 1801, so he appoints a commission. And just as a sense of how seriously Jefferson takes the issue, his commissioners are Secretary of State Madison, Secretary of the Treasury Gallatin, and Attorney General Levi Lincoln. Very high priority for the Jefferson administration, and the commissioners do decide that, yeah, the land title was revoked, but Georgia is going to cede all of this land to the federal government, and the federal government will compensate the investors. That is, they will pay them something so that they are not left holding the bag, as the Georgia legislature shows its superior virtue. So the Jefferson administration proposes a compromise, but the compromise is blocked by John Randolph of Roanoke, a very powerful figure in Congress who does not want to reward vice by paying anything to people who might have been party to all of this corruption and so on. Justice Wilson, by the way, had died bankrupt in North Carolina, fleeing from his creditors. And then this, the Republicans thought, was fitting for those who would try to enrich themselves by sacrificing public virtue. So nothing is going to happen, at least as long as Randolph has anything to say about it, or now Senator Jackson, who was reelected to the Senate from Georgia, have anything to say about it. And then in New England, some of the investors try a different strategy. Remember, Alexander Hamilton had said the state cannot revoke the land ordinance, and the state cannot make your property worthless. So what happens is this. In Boston, John Peck is an investor. He has some of the stock, some of the titles to this land in Georgia. He sells some of this land to Robert Fletcher of New Hampshire. Fletcher pays about $3,000 for 15,000 acres. If you're doing the math, you see now the price is about 20 cents an acre. It had been less than 2 cents back when Georgia made the deal. So the state, now Fletcher and Peck live in different states. And when Fletcher says to Peck, the land you sold me is worthless, he now can sue him in federal court. Now you may ask yourself, why doesn't Fletcher or Peck simply sue the state of Georgia? Well, it's because back in the 1790s, a fellow named Chisholm had sued the state of Georgia, and the Supreme Court had found for Chisholm, and Georgia got so upset saying the state cannot be sued, and other states also said, well, wait a minute, how come we can be sued? The Constitution had been amended. The 11th Amendment says that no state can be sued without its consent. It's the idea of sovereign immunity to protect states from being sued. So that's what had happened. So now Fletcher sues Peck, and saying that Peck sold me something that is worthless. Peck says, no, what I sold you is worth something because Georgia cannot rescind the act. Arguing the case for Mr. Fletcher will be our old friend Luther Martin, lawyer from Maryland, who says the states are sovereign. The states can do acts like this because the state legislature is sovereign, and if not the state legislature, then who? Arguing the case for Mr. Peck, saying the state of Georgia does not have the power to revoke the Land Act very distinguished counsel, Joseph Story, a lawyer from Marblehead, Massachusetts, former congressman from Marblehead, who later will be appointed to the Supreme Court by President Madison, John Quincy Adams, at this time a professor of rhetoric at Harvard, and Robert Goodloe Harper, a lawyer from Maryland. So very good counsel on each side, Martin arguing for the state's power to do this, and Story, Adams, and Harper arguing that the state does not have the power to do this. This is in 1809 when the court first hears the case, and one day actually they have to adjourn so that Luther Martin can sober up, and then another day they have to adjourn. This is on March the 4th of 1809, so that Chief Justice Marshall can administer the oath of office to President James Madison. And then the court in March of 1810 issues its ruling. And Chief Justice Marshall, actually it's a unanimous court that finds for Mr. Peck, and that is against the state of Georgia, saying that this is a contract the state had entered into, and the state then had simply abrogated the contract by rescinding this act. And the court says, yes, a state legislature can change laws previous legislatures have passed, but a state cannot change what has happened. That is, these folks who had acted under the law are entitled to relief. So it's really an issue both of the state passing a law which violates the constitutional prohibition of violating or impairing the obligation of contract, but also trying to pretend it never happened. One of the great lines from the court's decision is that the past cannot be recalled by the most absolute power. Marshall is saying that the state of Georgia is not a sovereign entity, not an all-powerful entity, and even if it is, it cannot change the past, something certainly that George Orwell would have appreciated. One justice sided with the majority, this is William Johnson, but dissented in part, saying the land didn't actually belong to the state of Georgia. It belonged to the Chickasaws, the Choctaws, and the Creeks. The state of Georgia did not have the power to sell it in the first place, but he found with the other justices that Georgia could not then rescind what it had done. And Johnson was also a little bit concerned that this was a collusive suit, that is, Fletcher and Peck had engaged in this transaction as a way of challenging the law and not through some good faith effort. You know, the court won't hear lawsuits that are made up. So this is Fletcher versus Peck, one of the great cases which somewhat puts an end to one of the big political controversies which had raged for about 20 years. The court says that Georgia cannot revoke an act. This is the first time the court strikes down an act by a state, although it earlier had upheld acts by states, which suggests the court could have done it either way. So Fletcher versus Peck puts an end to the Yazoo business. Well, not really. John Randolph, still in Congress, won't allow Congress to move at all to, as he puts it, reward these vicious speculators. So Congress has to wait until Randolph is out of Congress, and then it does appropriate $10 million to pay off these various folks who have been defrauded in the Yazoo land deal.